Good morning, everyone. Today we are going to do again the second part of our April current affair of political science. And the first article or the first news we have is about India's investigation agencies. Why is it in news? Because recently the Chief Justice of India, CJI of India, called for creating an independent umbrella institution. Why umbrella institution? Because then the various investigation economy. What is umbrella means this kind of thing which will enhance or which will take under the different CBI investigation things into itself. Okay, this is a big scheme which will include the smaller schemes of any government or any institution which are providing or making a umbrella. So now when we are talking about an umbrella institution, that means we are saying that the other institution which are independently working should be come into this one institution that can be changed on any name, right? So this was the recommendation by the CGI or the Chief Justice of India right now, who is DY Chandrachud ji, and he said that India needs an independent umbrella institution to bring various investigation agencies like CBI, enforcement, ED and serious fraud investigation under one roof. All right, investigation agencies in India, if we talk about that, then we have 2 to 4 type of investigation agencies. We will see independently or separately each, and we will talk about them. So starting from the CBI, what is about CBI, what you know about? Basically it's the premier investigation police agency in India. Police agency, it was established in 1963, and who was the establishment where it is established under? If we talk about the ministry even today, then it was Ministry of Personnel, Pension and Public Grievances. So mostly people thought that, oh, we are talking about CBI, that it must be under the home ministry, but it is not true, because most of the recommendation or accommodation has been provided by the home ministry to these services, but most of these agencies are under Ministry of Personnel, Pension and Services. So this is the important news for the prelims, and you can remember it. It's a very important. Next, if we talk about, it was how the establishment, who recommended about the CBI? So it was Sanathanam Committee on Prevention of Corruption 1962 to 1964, which recommended there should be a body like CBI who will see the corruptions of different person or different it's a highly intelligence police agency, right? So it will mostly based on the Sanathan Committee prevention of corruption report. Now it is a nodal police agency in India. It's a nodal it's a police agency, right? Nodal, what is the meaning of nodal? That is the head of the police agencies in India. So it's a nodal police agency in India which coordinates investigation on behalf of Interpol member countries. Now what is meaning of the Interpol member countries? That is different international police. So international police becomes a Interpol, and they coordinate with each other and then work with the at international sphere. What is the motto of the CBI? Motto of the CBI is that is very important. Firstly, it's a industry, then second it is impartiality, and third here is integrity. So this is the motto of CBI, integrity. And it is not a statutory body, and nor it is a constitutional body. Mostly when we talk about which type of body, either which things are mentioned in the constitution itself, they are known as constitutional bodies, like ESI, Election Commission of India, which are not mentioned in constitution and made by any law or by parliamentary act, that will known as statutory body, because they are placed under the statute book. So that is why they known as statutory body. But this is a special body which is nor a statutory, neither it's a constitutional body, but it is governed by Delhi Special Police Establishment Act 1946. So we got independence in I wrote, I guess, wrong. It was in Delhi Special Police Establishment Act 1946. 46, well, not 76, it was 46. And it focuses on combating corruption in public life, curb economic and violent crimes through meticulous investigation and prosecution. It helped to fight cyber and high technology crimes. We all are about that, aware about that. And then Lokpal Act 2014 provided the appointment of CBI director through high powered committee comprising prime minister. When we are talking about the CBI chairperson, okay, or we can say director, then it can be only selected by a high powered company. That who said this committee? This was recommended by the Lokpal Act of 2014. And again, Lokpals are the person who are individually administered the corruptions of the any MP or the person in the power or governance of group A and group B and C officers. They see if they are doing any corruption or not. So that the institution of Lokpal was made because of that. And then they said that the appointment of CBI director should be made by a high committee, which will include who? Prime minister. Then there should be other CGI there should be, and the leader of opposition. Alright, leader of opposition party, then they should all be into this committee, and they all come together and then choose who should be or appointed should be as a CBI director. Now be careful here that it is chosen by this committee but appointed by president. In 2021, president promulgated 2 ordinances to extend the tenure of the director of CBI or ED for up to 5 years from fixed tenure of 2 years. So we know that this was earlier 2 years, and 2020 president extend it to the 5 years. All right, and it provides assistance to Central Vigilance Commission and Lokpal. Now let's go and move forward to the ED. What is all about ED? ED's establishment has happened in the 1956, and with its headquarters are in New Delhi. So its headquarters are in New Delhi. Specialized financial investigation agency under Department of Revenue, Ministry of Finance, because it's handled mostly crimes or the issues related to the financial terms. So that is why this is into the Department of Revenue. Responsible for enforcement of Foreign Exchange Management Act, FEMA Act, and certain provision under Prevention of Money Laundering Act, PLMLA 2002. So FIO. What is FIO? Next, our body is FIO is a multidisciplinary organization under Ministry of Corporate Affairs. Consists expert in field of accountancy, forensic auditing, law, information technology, investigation, company law, capital market, and taxation for detecting and prosecuting or recommending of the prosecuting white collar crimes frauds. Its headquarters is again in New Delhi. Mostly headquarters of the agencies are in New Delhi. Even CBI has headquarters in New Delhi. According statutory status under Companies Act 2013, we all know that there is a Companies Act which was enacted by the Parliament, and this act is a newer act which repealed the earlier act, and according to this it is given a statutory status because in it they put this agency. Okay, so this given statutory status. Now we move forward and see, okay, what are the powers? So it has power to arrest accused people for violation of the company law. If someone is violating any company law and rules of that, then they can arrest that. It has that power to assist officer of FIO on investigation. The computer forensic and data mining laboratory was set up in 2013. Next and the last, we have National Investigation Agency, NIA. Now it is governed by its own act, NIA Act. It has its own act, and that is came into 2008, and its headquarters is in New Delhi. And it gives power to central agencies to take suo moto cognizance for terror activities across the country. So basically it's more prominent for the terror activities, and it was made after this 9/11. Okay, and in 2018 we had also 26/11 terror attack, by which it was think that okay, there needs something very prominent, very specialized in their work to stop this kind of terror attacks. So this happened after that, 26/11. Now give power to the central agencies to take suo moto cognizance. We already have discussed it, that it has suo moto powers, that they can already by self by itself they can take any action toward to cognize or to stop any terror activity across the country. It doesn't apply on particular state. It doesn't need any state's permission. It can do itself, because it has been made like that. Governing body, if we talk about, it's the Ministry of the Home Affairs and functions as central counter-terrorism law enforcement agency in the country. Now, analysis of the functioning of investigation agencies. First, there are multiple agencies. See, single incident is investigated by multiple agencies, often lead to dilution of evidences, a contradiction in deposition, overlapping of power, and prolonged incarceration of innocence, right? So that is a big issue, and that is a big problem. That is why CGI is saying that okay, we need something to do, something reforms are needed to be done in the investigation agencies strata. Second is delay in trials, lack of public prosecutor and standing counsel, seeking adjournment, filling voluminous documents in pending trials, under imprisonment of under trials, cherry picking of the evidences, and repeated transfer of officers, leading to unnecessary delays in the investigation. Third here is journal consent. Now, journal consent, when a journal consent is withdrawn by several states like Mizoram, West Bengal, Maharashtra, etc., CBI needs to seek case-wise consent from the concerned state for investigation. Now, CBI officer thus lose all the power of a police officer as soon as they enter the state, unless the state government has allowed them. This is a big problem. This is not happening with the NIA, but CBI has do not very much power to go and interfere or do anything according to suo motu. So that is why the CBI lose power according to when they are entering in any state without their permission. Section 6 of the DPSP Act even empowers state government to give or deny consent to CBI officer. And CBI investigate three type of cases here. Let's talk about that. First is anti-corruption. These are usually registered against public officials, employees of the union government. The superintendence of CBI related to investigation of offence under the Prevention of Corruption Act 1988 lies with CVC. Alright, now the second category is specialized crime. What are they? Investigation of serious and organized crimes under IPC and on request of state government or order of Supreme Court or High Court. This is the again work of them. Now, third category is economic offense, which are even eventually are done by even SFIO also, but they are also engaged them. These are crimes of financial malfeasance, bank frauds, money laundering, black money operation, etc. However, CBI usually transfer cases of money laundering to the Enforcement Directorate, ED. They send them. If we talk about suo motu powers, then CBI can suo motu take up investigation of offences only in union territories, UTs, because UT do not have state government. Alright, and there are exceptions, although like Delhi and we talk about Puducherry, there are exceptions. These two UTs are exception, but otherwise they do not have, and they are administrated by direct rule, right? The governor is the lieutenant governor, are the real administration and doing the work, all work required by that. So that is why they are given suo motu only on the investigation in the UTs. Center holds the power to authorize the CBI to investigate a crime in the state only after the consent of concerned state. However, if we talk about the Supreme Court and High Court, they can order CBI to investigate a crime anywhere in the country without the consent of a state, because these are the power of the High Court or judiciary. These are the power of the judiciary. They do not need any permission for any parliament or state legislature, and that is why after getting order from High Courts or Supreme Court, they can then go without the consent of any state enter any state and do their work. Fourth, if we talk about inadequate infrastructure, how? National Investigation Agency is a nodal counter-terror body, but it's still lacking infrastructure, manpower, fleet of vehicles to conduct investigation, and quick mobilization. And fifth, we have is falling credibility. See, basically, when we talk about these investigation agencies, the only and one thing is about their credibility. Every single person in this India, in this country, have more faith than any police agency into the intelligence agencies. And after that, these images of investigation agencies like CBI, ED and SFIO has been tarnished by allegation. Sometimes it's the allegation of corruption, sometimes it's the excesses, sometimes lack of impartiality is also seen here, and also a close nexus with the political class. This is the most important one, the close nexus with the political class. Political, they should be impartial without any interference by the political member or anyone. And that is why, example, if we talk about of this is we can see the Hawala scandal, then there was Boforo scandal. So CBI denied information, claiming exemptions under section 24 of Right to Information Act, thus hampering somehow it's public accountability. If we talk about the public accountability, it is hampering that. Next we have of the lack of autonomy. Agencies like CBI is administratively and financially dependent on the Department of Personnel and Training and lacks financial and functional autonomy. That is very important, that is very true as well. Next we have federalism. See, central government decision of interest the pan-India investigation of offences to any agency without the consent of the state government violates constitution, as public order or policing are matter of the state government. And there we have UPA as well. Unlawful Activities Prevention Act 1967, it was formed in 1967, is one of the acts that were added to the schedule of the NIA, that is National Investigation Agencies Act. The agency is given pan-India jurisdiction to investigate offenses covered in this act. And that is also, again, this is also became a problem. This is also, these are the whole reasons that we are talking about these reforms in this. So let's see what can be the reforms and what reforms needed in investigation agencies right now. First of all, we need, as CGI suggested, that there should be an umbrella organization, and somehow and to some extent it is required to bring various agencies under one roof to improve coordination, resources and intelligence sharing, along with clearly defining its powers, functions and jurisdiction. That is the most important thing, that they should be clearly defined. All right, next we have the regular upgradation. How there is a need for regular upgradation of knowledge, deployment of state and art technology, international exchange should be done here. And if we talk to new thing, there should be learning in the best practice. There should be some coordination to the other countries, other intelligence agencies. There should be exchange of learning between both. Third, if we talk about the performance audit, annual audit of the performance of the institution by the appointing committee to address loophole and improvement and to improve the efficiency of the investigative agency is very much the require of the hour or need of the hour. Now fourth is autonomy. The agency should be made independent with functional autonomy without the administrative control of government. Its directive should be given power of the secretary to the government and should report to the prime minister or the minister concerned directly. Director should have that much of power. Now fifth is women participation. See, there is a need for more women's representation in the policing system so that the woman victim feel confident to approach and report crime. That is very important. Number 6 is improving credibility. We already take that there is a lackness in the credibility to some extent, and to somehow they lose their credibility because of the previous past or the acts done by some example of the acts we have. So now there should be a harmonious relationship and collaboration between the state and central agencies to reclaim social legitimacy and public trust by breaking the nexus between the political executive. It is very essential that all institutions, including police and investigation bodies, uphold and strengthen democratic values and not allow any authoritarian tendencies to creep in. Next, let's move forward. Now we are going to see about the prison reforms. What is prison? Where the people who does any crime are situated, they cannot go away, or where the criminal, when they are accused, they are planted in. Now why it is in need? Because Ministry of Home Affairs MHA issue guidelines for implementation of modernization of prisons, MOP project. Now what is the MOP project? Let's see this. What is MOP, modernization of prison project? Basically government of India has decided to provide financial assistance. So alright, they are given by financial assistance to the grant or in form of grant in aid to states and UTs. Both are included through MOP for using modern day security equipment in prison. First, for enhancing the security. This is important, enhancing the security of the jail. And second here is to facilitate the task of reformation and rehabilitation of prisoner through correctional administrative programs. Now during the project, it is for 5 years, basically it is planted, it is from 2021 to 2026, duration is for 5 years. And what are the objective of these plans? If we talk about the objectives, then there are, first objective is filing the existence gap in security infrastructure of the jail. Second, there is providing new security equipment to the jail with modern technology. Third, we can take strengthening the jail security system, again this is the objective. And number fourth is here, focus on correctional administrative. We should make the people correct and should change their behavior so they do not become a habitual offender or habitual criminal kind of category. So that should be done for the better sake of the society. Okay, now project will cover all state and UTs and shared broadly cover the following prison types, like central jails will be cover here, then second district jails are also cover here, third there should be sub jails which are also covered, fourth women jails are also covered, and fifth open jails should be covered here. And there is one category of jail are also which is extend, and it is extended to the special jails, etc. So they are extended to these jails. Now what are the core components of MOP project? There should be video conference infrastructure, body worn cameras, door frame metal detector security poles, etc., baggage scanners, frisking, search, jamming solution, correctional programs, etc., which are going to cover there. Let's see what is the background. See, prison is a state subject, that is the most important. What is the, we have 7th schedule 7 in our constitution, which give us three list. First is your central or union list, known as union list. Second, we have state list and UT list also, and third we have concurrent list. All right, so there are various topics, like state list there are 98, there is 57 or 58 topics, and concurrent we have again something 48 to extra topics. Now what are these topics? These topics are the things which are under jurisdiction or the powers which are provided to the state, which are provided to the this union, and the concurrent are residuary powers which are provided to the both. But the centers, if union wants to make any law, that's decision will always prevail. All right, so this is the thing. Now prison is subjected to the state subject and under list 2 of the 7th schedule in the constitution. The management and administration of prison falls extensively in the domain of state governments and is governed by the Prison Act 1894 and the prison manuals of the respective state governments. However, here we can see it's a 1894 Prisons Act. However, the Ministry of Home Affairs provided regular guidance and advice to states and UTs on various issues concerning prison and prison inmates. What is the need for prison? Why there is any need for these prison reforms? First, there is an overcrowding problem. See, there is a report by Prison Statistic of India brought out by National Crime Record Bureau and NCRB. This report was given, and this report directly stated that in 2019 there were nearly 4.8 lakh of inmates in 13,600 these facilities. Against the sanction strength, there should be only 4.1 lakh, but there is 4.8 lakh inmates that are there. So this is the problem. They will occupy rate of 118%, right? It's more than what needed to be done. So this undermines the ability of prison system to meet the basic needs of prisoners such as health care, food and accommodation. Now this is also endangered the basic rights of prisoners, including the right to have adequate standard of life and the right to have attainable standard of physical and mental health. Second is no separation of under trials. This is very important and very somehow to say that it's very harming of the mental health to the person who is accused of anything and still is not acquitted. All right, either not acquitted, either not criminalized. So these both things are not happened to him, but still they are not separately taken care about. Now see, around 75% of inmates in our jails are under trial. That is very, we know this because we know judiciary, and we know that almost 4.40 crore cases are going under trial right now in the Supreme Court and other high courts and district courts right now. And the inmates, the jail, the person are in jail are under trial. They are not even acquitted, they are not even sentenced, they have not even sentenced, they are just acquitted and considered as a criminal by the society, even though they are not proven to be. Now see, as these awaiting trial inmates come into touch with their incarcerated inmates, they get influenced into the world of the crime. Health consequences of the imprisonment is also there. For example, prisoners' health condition deteriorates in the prison, which are overcrowded, where nutrition is poor, sanitation is inadequate, and access to fresh air and exercise offer unavailable. Third, we have this imprisonment and poverty. There should be poverty here. And when we're talking about imprisonment or prisons, imprisonment contributes directly to the improvement of the prisoner, of his family experiences financially losses as a result of the imprisonment of one of its member. Then it has exacerbated by the new expenses that must be made, such as cost of lawyer, food for the imprisoned person, transport to the prisons for visit, and so on. There is severe staff crunch as well. There is a very less staff as compared to the inmates, and about 30% of the sanctional jail executive staff posts are still live vacant. At national level, there is also average 7 inmates per staff in all jails in India. There are 7 inmates per one person. Issue of women prisoners, there is a severe lack of female staff, first thing. Second thing is there are inadequate number of toilets. Third is there is a bathrooms and other basic precondition of the sanitation and hygiene. There is a lackness of that as well. And also physical and sexual violence is very common scenario in the prisons. Next, we have our detrimental social impact. Imprisonment disturbs relationship and weakens social cohesion. The disruption of the family structure affects relationship between the spouses as well as between parent and children, and reshaped the family and community across generations. COVID-19 induced changes. What are the changes induced by COVID-19? Many prison systems have failed to implement critical COVID-19 preventive measures. People in prison are especially vulnerable due to compared living condition, lack of hygiene supply was seen there, hygiene supplies, and poorer health status as well was seen there here. Next, what is the way forward? What can be done right now? See, basically there can be issue of overcrowding, which can be addressed by first open prison. See, open prison, and how and why this is addressed. See, it's a correcting the behavior of the person, and that is why known as correctional institution, in which inmates are trusted to serve out their sentences under limited supervision and are not often locked up in the jails. They are free to go to work and return to the jail after working hour. This is done. So this is open jails, and this can be done to improve the issue of overcrowding. Improving the system of parole also is needed right now, so that inmates can maintain their social links while out prison are less cramped. Grant of parole and furlough must be balanced against public interest and can be refused to certain categories of the prisoners. Third, can be done by improving the fast track courts. Fast track courts should be established so that no innocent prisoner should be forced to spend too much time in the jail. Alright, next, what are the important reform measures that are taken by from India, or the initiative India? And the modern prison system was conceptualized by the T.B. Macaulay in 1835. So Macaulay is very known person in this, T.B. Macaulay, and in 1835 he established this modern prison system. In 1836 a prison discipline committee was constituted by the William Bentinck, who was also first Governor General of the India, and to improve discipline in the prisons. Now, Prisons Act in 1894 enacted to bring uniformity in the working of the prisoners in India. The act provided for classification of prisoners. All India Jail Committee 1919 to 1920 was first ever comprehensive study that was launched on this subject. Second, then came All India Jails Manual Committee, that was from 1957 to 1959, to prepare a model prison manual. All India Committee on Jail Reforms 1980 to 83 under Justice A. N. Mullah in 1987, the Government of India appointed the Justice Krishna Iyer Committee to undertake a study on the situation of women prisoners in India. Draft National Policy on Prison Reforms and Correctional Administrative in 2007. Model Prisoner Manual 2016 aims at bringing in basic uniformity in the laws, rules and regulations governing the administration of prisons and management of prisoners all over the country. Supreme Court has constituted a 3-member committee in 2018 to look into entire gamut of prison reforms across the country and suggest measures to deal with them. Report on women in prisons by Ministry of Women and Child Development in 2018 also seen there. Now, what is difference between parole and furlough? Parole is granted to the prisoner to meet a specific exigency. It is not a matter of right to some extent. It is a system of releasing a prisoners with suspension of the sentence. It can be suspension. Furlough. What is furlough? May be granted after a stipulated number of years have been served without any reason. Period furlough granted to a prisoner is treated as remission of its sentence. That means the sentence is ended. And when we are talking about parole, that means the sentence is suspended, not ended, not completely ended. Now, adherence to key international rules and standards such as Nelson Mandela rules. So we first talk about that right now. What are national Mandela rules? They are also known as UN standard minimum rules for the treatment of prisoners that set out the minimum standard for the treatment of people in prison and for good prison management. Second, we are having Bangkok rules. What are these? These are human rules for the treatment of women prisoners and non-custodial measure for women offenders. See, these rules give guidance to reduce unnecessary imprisonment of women and to meet the specific needs of women who are imprisoned. Third, we are having Tokyo rules, which are these all 3 rules are implemented in India. So these are again initiative. We already see what are the initiative taken by the India into India from itself, and these rules we are adhering to these 3 rules. Now the third one is Tokyo rules, known as also UN standard minimum rules for non-custodial measures, provided a set of basic principles to promote the use of non-custodial measures and sanctions as well as minimum safeguard to the prison subject of alternative to the imprisonment. Now, other than this, what can be done? First, can be done of use of technology. Automation and other technology advances can significantly ease the burden on prison staff, although the use of such technology needs to be balanced with the necessity for critical interaction between the prisoner staff and people detained. Second, can be a national commission for prisons. See, it should be, here it's mistaken by poison, but it is prison. Okay. Now, should be established to provide a national perspective on the prison and be a central body responsible for this. Third, can be a robust grievance redressal mechanism. There should be a robust grievance mechanism system should be there, should be put in the places in all the prisons to ensure the right of prisoners are not violated and their concern are heard impartially. Now, next we have healthcare needs. See, both physical and mental health needs should be addressed appropriately and regularly. Most important, inmates should be have access to the doctors and psychologists, and when they need, they should be provided by that. And the last one is skill development. Education facilities, vocational training and skilling facilities in the prisons should be upgraded as it can improve the daily lives of the prisoners and give them economic support after release. Let's move forward. Next we are having with us is phone tapping. What is phone tapping and why it is in news? Because the Indian Telegraphic Act 1885, there are powers for phone tapping, there are ground for phone tappings, there are power to issue the order for phone tapping. But before that, let's see why it is in news. Recently, an IPS officer was under probe for tapping the phones of political leaders in 2019. An IPS officer. All right. So, what are the constitutional provision on phone tappings? Basically, Schedule 7th. Again, I already told several times that schedule table tells us of the constitution about the powers of the union, state and concurrent. All right, union, state and concurrent here. So 7th schedule of the constitution provides or tells the telephone along with other communication devices find mention under entry 31 of the union list. It is under the union list. Right to privacy. Telephone conversation is a important facet of a person's private life. Telephone tapping would thus interfect Article 21 of the Constitution of India unless it is permitted under the procedure established by the law. Freedom of speech is there. If a person is talking on the telephone, she is exercising his or her right of freedom of speech and expression. This telephone tapping would also infringe Article 19(1) unless it comes with the restriction on the right set out in Article 19 subclause 2. Now about phone tapping definition. Phone tapping refers to the monitoring of internet based communication and phones by the third party by secret means. The word phone tapping also means wiretapping or line buzzing or interception of the phone. It was first common in the USA in 1890s after the invention of the telephone recorder. Legal provision. Phone tapping is regulated by the Indian Telegraphic Act 1885. The Indian Telegraphic Act. Now we are going to move forward. And what are the powers for phone tapping? Both the central and the state government have a right to tap phones under section 5 of subclause 2 of Indian Telegraphic Act 1885. In the states, police have the power to tap phones. At the center, 10 agencies are authorized to do so. Like first is Intelligence Agency IB, then second is CBI, Enforcement Directorate, Narcotic and Control Bureau, Central Board of Direct Taxes, Directorate of Revenue Intelligence, National Investigation Agencies RAW, and Directorate of Signal Intelligence and Delhi Police Commissioner. They are all allowed. Tapping by any other agency would be considered illegal. So now the second question aroused here is, what are the grounds for phone tapping? See, phone tapping can be done by the center or state if they are satisfied that it is necessary in interest of the public safety, sovereignty and integrity of India, security of the state, friendly relationship with foreign states, and public order for preventing incitement of the commission of an offense. Now this can be again divided in exception of the press. There is an exception for the press. Press message intended to be published in India of corresponds extradited to the central government or a said government shall not be intercepted or detained unless this transmission has been prohibited under this subsection. Power to issue the order for phone tapping. Who has this power? According to Rule 419A of the Indian Telegraph Amendment Rules 2007, phone tapping orders could be issued only by the Secretary under Ministry of Home Affairs or his state counterpart. The order has to be conveyed to the service provided in writing. Only then can be tapping begin. The competent authority must record reason for tapping in the writing as well. However, in the exceptional cases, the order may be issued by the lower authorities also, which may include officer not below the rank of a joint secretary, to the government of India, or to the head of the second senior most officer of the authorized law enforcement agency at the central level, and by authorized officers not below the rank of inspector general of the police at the state level. Such orders has to be communicated to the competent authority within a specified time of period. Now, what are the common phone tapping technologies right now India is having? First is process of tapping, integrated service digital network. We all have SDN right now, and the second one is leased line. So when we are talking about process of tapping, how it is done in ISDN, a mediation service intercept a call and then transmit it through a primary rate interface that can be known as PRI. Here PRI is not Panchayati Raj institution, but here PRI is primary rate interface line to the office of a government agencies. Also, the police can listen to the phone on the PRI line and store the recording to the attached computer. A sound file of the intercepted call is also recorded and stored in the mediation service simultaneously. Now, leased line. The service provider gives the agency direct access to its backbone network through a dedicated fast-speed fiber optic cable connection. If we know about the time lag, then in ISDN, the transfer of call-related data doesn't happen in real time. It's a slow 64 kbps speed result in a time lag of 2 to 3 minutes. But in legs in this line system, the call-related data is not only transmitted in real time at the speed of 2 Mbps, the chances of missing any call are minimal. Advantages: ISDN, these are cheaper, and these leased lines are costly, as cost of laying a fast speed fiber optic cable connection is little higher. If we talk about utility, then state agencies are more dependent on ISDN as it is cheaper. Now, there are some important cases also about the phone tapping. Just we have first case of PUCL versus Union of India 1996. It held telephonic tapping infringed the fundamental right of the privacy and created safeguard against arbitrariness in the exercise of the state surveillance power. Second case was there of KLD Nagashri versus Government of India 2006, held the occurrence of any public emergency or existence of a public safety interest is the sine qua non under section 5.1 and under section 5.2. Then there was third case, that was Rayala M. Bhuvneshwari versus Naga Parindra Rayala 2008, held act of tapping conversation of wife by husband is illegal. Alright, now what are the checks of misuse against power of phone tapping? First is last resort. First we can see here is last resort. What is the law is clear that interception must be ordered only if there is no other way of getting the information. Second, there is a time limit. The direction for interception remains in force unless revoked earlier for a period not extended 60 days. There is a 60 days time limit, and they may be renewed but not beyond a total of 180 days. So overall, if we say that no one can tap your phones more than 6 months in a year. Alright, next is their review committee. Any order issued by competent authorities reviewed by a committee headed by the cabinet secretary with law and telecom secretaries as its member. In state, it is headed by chief secretary with the law and home secretaries as member. The review committee may set aside the direction and order for destruction of the copies of the intercepted message or the class of messages. And next we are having destruction of records. Record pertaining to such direction shall be destroyed every 6 months unless these are likely to be required for functional requirements. Service provided too are required to destroy records pertaining to direction for interception within 2 months of discontinuance of the interception. Next we have procedural transparency. There are multiple provisions aimed at keeping the process transparent. First is written direction to the service provider. Already saw that the direction for the interception have to be conveyed to the designated officer of the service provided in writing by an officer not below the rank of SP or additional SP or equivalent. Disclosure of information. Direction for interception are to be specified the name and designation of the officer or the authority to whom the intercepted cell is to be disclosed. That is also very important. And the last resolution is responsibility of the service provider. The designated nodal officer of the service providers are supposed to issue acknowledgement letters to the security law enforcement agencies within 2 hours on receipt of an intimation. They are to forward every 15 days a list of interception authorization received by the nodal officer of the security and law enforcement agencies for confirmation of authenticity. Next we have they shall put in place adequate and effective internal checks to ensure that unauthorized interception of the messages does not take place and extreme secrecy is maintained. In case of unauthorized interception, the service provided may be fined or even lose its license. That is also important. Now, what are the resources against illegal phone tapping? Unauthorized tapping is in violation of the right of privacy, and aggrieved person can file a complaint to the Human Rights Commission. Now here is it cannot directly go to the writ jurisdiction of the constitution, that is fundamental right, and he cannot go directly to the Supreme, but rather than it can Human Rights Commission. It can file a complaint in Human Rights Commissions, and a FIR can be lodged in the nearest police station when unauthorized phone tapping comes into the knowledge of the person. Additionally, the aggrieved person can move the court against the person company doing the act in authorized manner under section 26B of the Indian Telegraphic Act, which provide 3 years imprisonment or jail to the person held for tapping. The person can also be prosecuted for the authorized tapping, but sharing of the data is an unauthorized manner. Next is India stays out of global declaration of future on internet. What it's about? Basically aiming to keep the internet open, free and neutral. The declaration is politically commitment among the partners to advance a positive vision for the internet and digital technologies. Around 60 countries have signed the declaration, including US, European, India, United Kingdom, Canada, France, and India, China and Russia are among the large nations that are not part of this declaration. Very important. India with China and Russia not part of it, right? So if pre ask this question and give in prelims not a part, that means yes, India is not a part of it. Now, key principle. What are the key principle of that declaration? Commitment to protect human rights and fundamental freedom of all people, promote a global internet that advance the free flow of information, advancing inclusive and affordability connectivity, promote trust in the global digital ecosystem, including through protection of privacy, protecting and strengthening the multi-stakeholder approach to governance. Earlier, a report titled The Return of Digital Authoritarianism, Internet Shutdowns, highlights that number of countries that shut down the internet in 2021 has increased to 34 from 29 in 2020. India is the top country to impose internet shutdowns in 2021 for the fourth consecutive year. India also did not sign the Budapest Convention on Cybercrime in 2001. The data sharing provision for Budapest Convention infringes on national sovereignty. Presently, it is the only legally binding multilateral convention on cybercrime and electronic evidences. Let's talk and move forward to the next. Next is the Department of Personnel and Training, DOPT, lays down norms for quota in promotion. The DOPT has asked all department of central government to collect the data on inadequacy of the representation of scheduled caste and scheduled tribes before implementing the policy of reservation and promotion in government offices. The memorandum referred to the January verdict of the Supreme Court upheld in M. Nagaraj versus Union of India in 2006 judgment, having three conditions were laid down by the apex court. The first one is the collection of qualified data regarding the inadequacy of the representation of Supreme Court and scheduled castes and scheduled tribes. The application of this data to each cadre separately, the cadre being the unit of operation of the promotion roster, and reservation in promotion. Article 16(4)(a) empowers state to make provision for reservation in matters of promotion to Supreme Court and this scheduled caste and SCs and STs. Now, Nagaraja versus Union of India 2006, Supreme Court laid down three criterion to followed for implementation of reservation in promotion. Jarnail Singh versus L.N. Gupta 2018, Supreme Court held that state need not to be required to collect quantifiable data on the backwardness of the this SC and ST. Now, what are these Department of Personnel and Training lays down some laws for quota in promotion. There is a quota in parliament. This is the history given. 1992, in Indira Sahni versus Union of India cases, Supreme Court holds reservation in promotion is unconstitutional. In 1995, 77th constitutional amendment introduced as Article 16(4)(a), providing for reservation in promotion if states feels needful. In 2006, in M. Nagaraja versus Union of India, Supreme Court holds that amendment but says that state would have to satisfy the test for backwardness with qualification data. 2012, Supreme Court struck down UP sanitary rules which provided for reservation in promotion, saying UP has not undertaken any such studies on backwardness. In 2012 itself, in September, Congress-led UPI government introduced Constitution's 117th Amendment Bill seeking to substitute Article 16(4)(a) with on article that the SCs and STs should be considered as backward. In 2012, bill passed by Rajya Sabha introduced in the Lok Sabha but could not pass and lapsed in 2014. 2018, a 5-member SC Supreme Court bench says reservation in promotion could be implemented with the creamy layer exclusion principle for SC and ST. In 2019, reservation in promotion stayed by Supreme Court. In 2019 itself, Center Fly's review plea that a 7-member constitution bench hear the matter. Till now it's not here. Now next is rule for resignation and reinstatement of an Indian Administrative Service or IAS officer. What are the rules for his resignation? In 2019, an IAS officer who resigned from service has been reinstated. The resignation of an officer of any of all three All India services, that can be IAS, IPS and Indian Forest Services IFS, is governed by Rules 5 subclause 1 and Rule 5 subclause clause 1 and subclause A of the All India Services Death Cum Retirement Benefit DCRB Rules 1958. There are similar rules for resignation. There are similar kind of rules for resignation of officer belonging to other central services as well. Now, rules to withdraw a resignation that has been already submitted. As per DCRB rules amended in 2011, central government may permit an officer to withdraw his or her resignation in the public interest. If an officer who has submitted his or her resignation sets an intimation in writing withdrawing it before its acceptance by the competent authority, resignation will be deemed to have been automatically withdrawn. Now, central government shall not accept the request for withdrawal of resignation when a member is associated with any political parties or any organization which take parts in politics. 2. To take part in assistant in any other manner any political movement or political activity to canvass or use of his her influence in connection with or take part in election to any legislature or local authority. Resignation of an IAS officer must be submitted to the Chief Secretary of the state in case of an officer serving in the state. Now, second, Secretary of the concerned ministry or department in case an officer who is in central deputation. Only after recommendation of concerned cadre or state is received, the competent authority, that is the central government, consider the officer's resignation. Competent authority are Ministry of State and Department of Personnel Training DOPT at respect of IAS, Ministry of Home Affairs in respect of IPS and Ministry of Environment, Forest and Climate Change in respect of IFS. Next we are having the fast and secure transmission of electronic recorder. That is also known as FASTER. It's a very prominent, I can say, for the prelims news. Let's see. Recently, CGI launched the FASTER, a digital platform for court officials to instantly send e-copies of the order. It will transmit e-authenticated copies of the interim orders, stay order, bail orders and record of proceedings of the duty holder for compliance and due execution through a secured electronic communication channel to intended parties. It is developed on direction from Supreme Court after suo motu cognized on daily release of the convict from jail after court order. Now, next is Broadcast Seva Portal. What is this? It is an online portal solution for speedy filing and processing of application of broadcaster for various kind of licenses, permission, registrations. It is launched by Ministry of Information and Broadcasting. It is a simple and user-friendly web portal that provides a broadcaster with the end-to-end solution and would bring transparency, accountability and responsiveness in the ecosystem. It will reduce the turnaround time of application. At the same time, it will help applicant track the process. Now, the next we are again seeing is basic structure doctrine. It's a very important doctrine. I guess we all are aware mostly about this. Now, why it is in news? Because the landmark Keshwa Bharati judgment 1973, which propounded the basic structure doctrine, completed 50 years. About the Keshwa, because it's in 2023. and Keshwa KBC case came in 1973, so it's almost 50 years completion, and that is why it is became important for the main perspective as well. Now, what is the Keshwananda Bharti case? The case dealt with the petition against the Kerala government challenging the compulsory acquisition of his land by the government under the Kerala Land Reforms Act 1963 as a violation of the fundamental rights as enshrined into the Article 25, 26 and 31 of the Constitution. Right now we do not have Article 31. It has been repealed and made a legal right under Article 300A. Okay, now it's not a fundamental right. The case was heard by a bench of 13 judges, the largest form in the Supreme Court ever. Key outcomes: introduction of basic structure of doctrine. Supreme Court validity of the 24th Amendment and held that Parliament has the power to amend any or all provision of the Constitution, including fundamental right, with a condition. That was the main thing. The condition was that the amendment should not alter, damage or destroy the essential features of the fundamental principle of the Constitution. These came to be known as basic structure doctrine. Corrected judgment of the Golka Nanda case. The Supreme Court held that Article 368, which is the power of Constitution itself, that Constitution can be amended. So this is the power of amendment. Article 368 in Goloknanda case, and Supreme Court tells that how this Article 368 contained both the power and the procedure for amending the Constitution, and that amending power and legislative power of the Parliament were different. Other judgments were also there, like Supreme Court upheld the 25th and 29th Amendment except for the parts that curtail its power of judicial review, and also asserted that the preamble is a part of the Constitution and hence amendable. And on which date this date come? It is came the 24 April 1973. It should be remembered, because this also came into the part of citizenship when they are talking that okay, if someone is came before 73, again it's get implemented in the 9th schedule of the Constitution when they that before the areas or the topic including before 24th April 1973 cannot be judicially reviewed. No judicial review can be done on them, but after this date any topic or anything which is placed under schedule 9 of the Constitution can be reviewed by the judiciary. Then it's a thing. Now, what is the basic structure doctrine? The basic structure doctrine holds that certain fundamental features of the Constitution cannot be amended or abrogated by the Parliament through a constitutional amendment itself. There is no mention in the terms of basic structure anywhere in the Constitution of India. But if we look at what are some present part of the different cases where Supreme Court itself identifies some basic structure, then we find that sovereignty of India is a basic structure. Essential features of the individual freedom secured of the citizen, again it's a basic structure. Mandate to build a welfare state, that is given into the Supreme Court, and that is said not in the Supreme Court, in DPSP in the Constitution itself, and said that it's the soul of Indian Constitution. It's said by the P.R. Ambedkar. Then DPSP's that is why this is mandate to build a welfare state. Supremacy of the Constitution, that is very important and differentiate us from the British Constitution or British Parliament, because in Britain the supremacy or the sovereignty of Parliament is bigger than the Constitution, but we have Constitution is supreme. Now, Republican democratic form of government, secular and federal character of the Constitution, separation of power between the legislature, executive and the judiciary is again a basic structure. Unity and integrity of the nation, power of judicial review itself is a basic structure. Harmony and the balanced power, fundamental rights and DPSPs. Now, if we move forward and see what are some significance, and if I make a diagram here, I can make, I guess, and tell you how this evolution of doctrine of basic structure has been happened. So it was started in 1950 when the A.K. Gopalan case came, and Parliament said that Parliament can amend any part including fundamental rights. Then came Shankari Prasad case. Okay, Shankari Prasad case came in 1950 when again Supreme Court said that Parliament can amend any part. Then came 1965, and in 1965 there was Sajjan Singh case, which again said that in Golaknath case, in Article 368, whatever happened, that Parliament has confirmed power to amend anything, but fundamental rights cannot be amended by the Parliament. Then comes the time in 1971. In 1971, there was a 24th constitutional amendment happened and 25th constitutional amendment happened. And in 24th constitutional amendment, court said that constitutional amendment not law under Article 13. So Parliament cannot amend. Now Article 13, we all know fundamental rights are from Article 12 to Article 32, and Article 13 gives definition of law. What is a law? These are the definition given, and they say that in Article 13, because constitutional amendment is not considered as law, that means it cannot be done on fundamental rights. It is first time given in this 1971 case, and also it was said in 1971 that fundamental rights of citizen are limited and Parliament can amend any part of this, alright, but cannot. See, 25th constitutional amendment came there. Section 2 curtail right to properly with due of compensation. Section 3 said precedence of DPSP over fundamental rights is very important and took away scope of judicial review. 1972 again Keshwanandi Bharti came case, and its judgment came in finally 24 April of 1973, which we are already discussing. And let's now forward to the significance of this doctrine. What are the significance? The significance of the doctrine is, first is the check on the power. See, its work as a severe as a check on the power of the Parliament to amend the constitution. Second, it is ensure that constitution remains a living document, because that is responsiveness of changing time while preserving its fundamental values and principles. That is important as well. Then third is principal bedrock of constitutional law. Laid down this doctrine laid down several principles that has become the bedrock of constitutional law in India, such as rule of law, separation of power, independence of the judiciary. Ensure that the federal structure of the constitution is not undermined. Instrumental in shaping the India's judiciary approach to constitutional interpretation. And there are, when there is some significance, there are some challenges as well. So what are some major challenges? Like first challenge is scope of basic structure itself. The interpretation of what constitute the basic structure is often constitute, which can lead to differing interpretation and confusion that can happen. Second is judicial activism. The use of basic structure doctrine allows the courts to invalidate constitutional amendments passed by the elected representative of the people, and that is the biggest criticism of this. For instance, in 2019 the Supreme Court struck down the National Judicial Appointment Commission NJAC, which we already talked in yesterday's newspaper, and act to reform the appointment of process of judges. Third, here is a conflict with parliamentary sovereignty. See, the doctrine is often seen as a limitation on the power of Parliament to amend the constitution, which can be perceived as a challenge to the principle of parliamentary sovereignty. For example, the move to remove special status of Jammu and Kashmir under the Jammu and Kashmir Reorganization Act in 2019 was challenged in the Supreme Court on the ground that it undermines federalism, secularism, and the right to self-determination. However, Supreme Court upheld the constitutionality of the act, and at last it is difficulty in amending the constitution. The doctrine makes it quite difficult to amend the constitution, even when such amendments are necessary to address changing societal needs. Now, what can be the solutions in this? What can be the way forward? The first can be done is clarity in the definition. The Supreme Court needs to provide a clear definition of the basic structure, including the fundamental principle and values that cannot be amended. Secondly, it can be done consistency in the application can be approved here. So the doctrine must be applied consistently in all the cases, ensuring that the basic feature of the constitution are not tempered by any organ of the state. Third, can be limited limiting judicial activism. The court should exercise restraint in interpreting the constitution and upholding the basic structure, respecting the separation of power and the role of parliament. And fourth here is public awareness and participation. There is a need for public awareness also and participation in understanding the importance of basic structure doctrine and its impact on the governance of the country. This can help in building public support and doctrine and its continued relevance in protection of the constitution. When application and evolution of basic structure happened, if we talk about that, we can say that in 1975, first time Indira Gandhi versus Raj Narayan, this was the case in 1975. The court used basic structure doctrine for the first time to strike down 39th Amendment Act, in which happened in 39th Amendment Act, which happened in 1975, provision that bared court jurisdiction over election disputes. Now in 1980, Minerva Mill cases, it's a very important case. Parliament's power to amend constitution must not damage or destroy the basic structure, it was said by the Supreme Court. In 1981, Vaman Rao case, Vaman Rao case, actually it's not Vaman now, it's Vaman Rao case in 1981, that said that basic structure doctrine will not be applicable retrospectively. That is why I given you example of the 9th schedule and said that how in 9th schedule some criteria, some topic which are placed under before 24 April 1973 cannot have effect of basic structure. They can't be judicially reviewed, but after this date anything put under 9th schedule of this thing or the topic can be reviewed by the judiciary. So what is showing, it's saying that it does not affect retrospectively, it can't go past and implement it. It is implementing after the date it has invented by the Supreme Court. Now next we have 1992 Quixoto Holohon versus Jachulo. 1992 is in this Supreme Court said that free and fair election was added to the basic features. 1992 Indira Sohane versus Union of India. 1992, rule of law was added to the basic features. In 1994, S.R. Bomai versus Union of India. 1994, federal structure, unity and integrity of India, secularism, socialism, social justice and judicial review were reiterated as a basic structure. So this was all about today, and thank you so much for being here. All the very best for your preparation and for your exam, and have a nice day. Thank you.